Hello, my name is David Lepofsky. I'm a visiting professor at the Osgoode Hall Law School, and I'm also chair of the Accessibility for Ontarians with Disabilities Act Alliance. The Aoda Alliance is a volunteer, nonpartisan coalition. We advocate to achieve an accessible society for people with all kinds of disabilities, especially through the effective implementation and enforcement of the Accessibility for Ontarians with Disabilities Act, or Aoda. Today, what I'd like to do is to give you a talk entitled Aoda 101. What is the Accessibility for Ontarians with Disabilities Act? Why was it enacted? How does it work? And a bit of how is it working? I'm speaking to you on an assumption that this is your first real introduction to this law. You may have heard of it before, but you have no idea exactly how it works. And my aim in the next hour is to give you a really thorough comfort level with how it works. So back 15 years ago, on the 10th of May, 2005, there was really an extraordinary day at the Ontario Legislature in Queen's Park here in Toronto. On the floor of the legislature, the Accessibility for Ontarians with Disabilities Act, or Aoda, was unanimously passed. All three political parties united, every MPP voted in favor of it. And not only that, but when it passed, they all rose in unison to give this law a standing ovation. Those politicians don't agree on much ever, much less to unite unanimously to applaud something they've done. But the miracle of that day went further, because right after that event, just down the hall at the legislature in the media studio, there was a press conference to applaud that legislation. Speaking in favor of it were three speakers. The cabinet minister who brought the law in, Dr. Marie Butriani, she's obviously going to speak in favor of it. She led its passage. Me, on behalf of the coalition that had fought for a decade to win its enactment, then called the Ontarians with Disabilities Act Committee, which I had the privilege of leading, and a representative of the Retail Business Council of Canada. Let me rephrase, the Retail Council of Canada. In other words, at the same time, we had Liberal, Conservative, and New Democrat uniting in the chamber of the legislature, and just down the hall, government, disability community, and business representatives uniting, all to applaud the passage of this law. That's a pretty extraordinary event. Does not happen often, if ever. Well, what was it that they passed, and why did they pass it? I lived that history, and I can tell you that story from personal experience. But today, what I'd like to do is just focus on the what. That legislation was aimed at addressing a problem that is, frankly, as old as society itself. Our society, like any other society, is unfortunately designed and operated too often on the basis that it's for people without disabilities. And when I say disability, I mean any kind of disability: a physical disability, mental, sensory, intellectual, learning disability, communication disability, neurological disability, and so on. Any of them. That is to say that our public transit systems, our buildings, our schools and colleges and universities and the curriculums they teach, our workplaces, our stores and the goods that are sold there, and indeed our laws and the justice system that administer them, all have been historically designed and operated on this unwritten, unarticulated, and yet pervasive premise. This is so even though people with disabilities are in every society. We're a substantial minority, and not only that, but frankly, these barriers hurt everybody, because everybody either has a disability now or has someone near and dear to them who has a disability, or gets a disability later in life as they age. Well, I've been talking about barriers. What kind of barriers am I talking about? What is a barrier? Well, the one that comes to mind for many when you talk about disability are physical barriers that would impede people with a physical disability. So, for example, steps to get into a building. And if you use a wheelchair or a walker, you can't go up those stairs. That's obviously one kind of barrier, physical barriers. And of course, there are many barriers in the built environment facing people with disabilities, not just those facing people who use wheelchairs. I, as a blind person, face barriers in the built environment where it's not designed in a way to accommodate people who can't see or who can't see very well. There are many other kinds of barriers too, not just that one that comes to mind most quickly. There can be technology barriers such as consumer technology, which is not designed to be used by people with disabilities. Technology that assumes that you've got two working eyes and two working ears and two working hands and so on to operate it. Think of going to the airport and they have those electronic kiosks to check in, but they're not designed to accommodate people with a range of different disabilities, of which mine is one of them. There's also web information barriers and communication barriers. Websites which are not designed to interact and be used by people who use adaptive technology when they use the internet. Maybe barriers facing not just people like me with vision loss, people who are colorblind, people with hearing loss, people who can't operate a mouse but use a keyboard or voice input technology instead to operate their computers. There are bureaucratic barriers. There can even be legal barriers. There are attitudinal barriers. A spectrum of different kinds of barriers, of which these are among the more prominent examples that can impede people with disabilities from fully participating in society. Now, are we just talking about old barriers? Well, of course, there are many old barriers in our society that have existed for years because of the fact that our society has too often been designed as if it's to be used only for people without disabilities. But as well, there are new barriers. Even as quickly as some old barriers are coming down, we're finding new ones are being created. Now, that might not make much sense to you, but it is something we encounter all the time, I regret. Let me show you a quick 2-minute video to illustrate the point. Many people think that buildings may have been designed in a way that's not accessible years ago because society didn't know better, but now we know better. We would always design a new building to be fully accessible. Well, regrettably, that's not the case. Our building codes and other laws on accessibility don't ensure that new buildings are properly designed to be accessible. My coalition produced a video that, in fact, we've done 3 different ones on 3 different built environment contexts showing new construction that's full of barriers in public places. The example I'm going to point to is the Ryerson University Student Learning Center in downtown Toronto. Now I'm going to show you a 2-minute excerpt from this video. It's been seen thousands of times, it's been used, been shown in the media and gotten a lot of attention here in Canada and elsewhere outside Canada. But if you want to see the longer version, just go to YouTube and search on Ryerson, R-Y-E-R-S-O-N, and Aoda, and you can see the 12-minute or 30-minute versions of it. Watch this video just as an illustration of new barriers that we have to face. Stairs. On one set of the main lobby stairs is a pillar in the middle of the stairs. I walk right into it. When I finally find the handrail on the right side of this bizarre column, it doesn't lead me up the stairs to the landing. Instead, it loops me past the top of the column and back down the adjacent stairs. There are stairs with angled railings outside the building going up to the front door. The main lobby staircase goes up 2 floors. Railings divide it into 4 parallel sets of stairs. The right handrail is skewed to the left, cutting in front of a person as they walk up the stairs. The left handrail is at a skewed angle too. If you hold the railing like I did, your feet are guided in the wrong direction. This is a tripping hazard for blind people and for those with balance issues. Staircase railing should never be angled. Designers may think it looks cool, but it creates safety and accessibility problems. On the 6th floor is a room called the beach area for students to hang out and study. Stairs go from the front of the room up to the back of the room. There's a landing between each short flight of stairs. The stairs don't follow a straight path from the front of the room to the back. Speeding up the video, see how lost I get. Ramps. Here's an outside ramp to get from the street level to the building's front entrance 1 floor up. The ramp's route is quite a maze. Normally, ramps follow a simple pattern, a straight line or switchback. That outdoor ramp has no railing. People with balance issues need a railing. I need one to follow a maze-like ramp. Angled pillars. Nothing should ever protrude at any height into a path of travel. No pillar should ever lean at an angle. When I go up the outdoor ramp from street level to the front door, there's a leaning pillar on my left side. My shoulder brushes right up against it. When I take that exterior elevator to the ground floor and walk outside, there's a leaning pillar in my path. I hit my head right near my right ear. It's troubling that this building won architectural awards. Here's a web page announcing that it received the Canadian Architect 2011 Award of Excellence. Accessibility deserves greater priority. So this is a pervasive and huge problem. Well, what do we do about it? Well, before the Aoda came along, we had made all of these barriers illegal. They violated the Ontario Human Rights Code, or within federal jurisdiction, the Canada Human Rights Act, and in the case of government organizations, they violated the Canadian Charter of Rights and Freedoms. One way or other, these barriers were all illegal, and organizations that had them had a duty to remove them and prevent them so that people with disabilities could fully participate in all the goods or services or facilities or jobs or other opportunities that are available that they offer. But what we had found, that the passage of those laws, the human rights codes and the Charter of Rights and so on, they were not effectively solving the problem. Yeah, they were tearing down some of the barriers, but not all of them, by any means. And they weren't preventing the creation of new barriers. Not only that, but for obligated organizations who wanted to do the right thing, if they said, I don't want to be full of barriers, I want to obey the law, if they picked up those laws and read them and tried to figure out what they got to do, they don't really explain it in any detail. So these laws didn't give any effective guidance to obligated organizations on what they need to do. And if you want people to obey the law, you got to tell them what they need to do. Making this even worse, those laws, the Charter of Rights and the Human Rights Code, required individuals to bring claims and proceed in either courts or before tribunals or human rights commissions to try to enforce their rights. And most people with disabilities don't have the time, the resources, the energy, and the access to legal services to do all that. So along came the claim that I had the privilege of, or the movement that I had the privilege of becoming part of and eventually leading, to say we need a new law to make those rights become a reality. It wasn't, the Aoda was not sought because we wanted new rights. We just wanted a law passed that would make those rights become a reality in our lives. We fought from 1994 to 2005, and on that miraculous day, May 10th, the law was passed and came right into effect. If you want to learn about the history of that law, you can learn by going to other lectures in this video lecture series, or go to the legacy website of the coalition that fought for it, the Ontarians with Disabilities Act Committee. That website is www.odacommittee.net, and it tells that story. But what did we win? Well, let me explain it to you this way. First, you have to understand what the purpose of the law is, and then what the means or tools that the law provided to achieve that purpose. The purpose of the legislation, of the law, is spelled out right early on. And it provides the goal is for Ontario to become accessible to people with disabilities. And it defines disability very broadly. Now, that goal of itself is quite a profound goal. It says it all. And it says it in a way that is uncompromising and unqualified. Others who've looked at doing legislation in this area have thought about maybe passing a law that says that they will improve accessibility. That's way too weak. You remove one flight of stairs somewhere and throw up a ramp. You've now improved accessibility. The rest of the place may still have lots of problems, but you can say you improved accessibility. No, this law set the goal as the true destination where we wanted to get to, and that was what the disability community was advocating for that decade from 1994 to 2005. So by accessibility, this means accessibility for people with all kinds of disabilities. The definition of disability in the AODA is very broad. It's as broad as in the Ontario Human Rights Code. It includes all kinds of disabilities: physical disabilities, sensory disabilities, mental disabilities, intellectual disabilities, learning disabilities, neurological disabilities, communication disabilities, the whole spectrum. It's very broad, and it defines barrier also very broadly. Accessibility contemplates both removing existing barriers and preventing the creation of new barriers. But this goal actually goes further. It doesn't just set what we want to achieve, but when we want to achieve it by. It set a deadline by which Ontario is required by law to become accessible to people with disabilities. And that deadline, set in 2005, was 20 years, or 2025. Now, back then it seemed like it was far off. Now it seems like it's extremely close. This was a substantial achievement and a substantial breakthrough. And the idea of setting a deadline came from the government, not from us. Why is the deadline so significant? Well, I've not seen any other law before this, whether in the disability area or in other areas of promoting equality for equality-seeking groups or human rights, which set a specific deadline to achieve the entire goal. Why was it 20 years? Because it was felt that that was the amount of time that would be needed to do all the work that was needed to remove all the barriers that were in society and to prevent new ones. So that is the first thing you need to know. And the moment this deadline was enacted, the moment this law was passed, the clock started ticking. So that deadline served not only as a guide to the interpretation of the legislation, but as an overall basis for judging all actions. Whenever we would look at actions the government would propose, more about that in a minute, we'd say, well, will that get us to accessibility by 2025? Are we on schedule? Are we moving forward fast enough? Or do we need to speed up to get to that goal? That was something we could ask at all points. And now we can ask the question whether just a few years before that deadline, are we on schedule? Sadly, we're not. More about that later. So, with this important groundbreaking deadline specified, how does this law work? Well, one of the most important things it does is it puts someone in charge. It's not good enough for governments to just go to legislature and declare that we will end poverty for children in 10 years and applaud and congratulate ourselves and then go back to business as usual. You need to have someone in charge. And this law, in effect, puts the government of Ontario in charge of achieving that goal. Now, it doesn't do it by requiring the government to go out and itself fix every barrier in any store, in any restaurant, any local school, or any taxi or whatever. That would be unrealistic in the extreme. Rather, it provides for the government a couple of major responsibilities. And that's what I'm going to spend the rest of my time talking about today. And the discharge of those responsibilities divide into two categories. And by implementing those responsibilities, if it does it right, it will get us to that goal on time. And we can judge how well it's doing in fulfilling those by seeing, are we on schedule at any point in time? So what are those two responsibilities? Well, first, at the core of this legislation is a requirement that the government enact a series of regulations called accessibility standards. It must enact all the accessibility standards required to ensure that the purpose of the law is achieved. What does that mean? It means it has to pass all of the regulations that will ensure we get to full accessibility by 2025. Let me spend some time on this, and then I'll get to the government's second major responsibility. What is an accessibility standard? Well, it's a regulation. A regulation is a law. It's an enforceable law. And it's a law that a piece of legislation can assign to cabinet or some other organization the power to make. Normally the legislature passes a law, but it can give to the cabinet of the province or some other official the power to make a defined set of laws and set the rules how they are to be made. And those are called regulations. They're as much a law as a statute, but they're not passed in the legislature. Now, normally laws provide that a standard, a regulation may be made by cabinet or whoever, and that's it. The Aoda goes further, I'm going to spend time on this in a couple of minutes, and sets out a detailed process of how they are to be made, and it's a process that we negotiated very carefully for because we wanted these procedural protections built in. But before I tell you how they're made, I've got to talk to you about what they are. What is an accessibility standard? Well, the idea is that an accessibility standard will be a set of rules that will spell out exactly what an organization needs to do to become accessible in a particular area of activity. So remember I said a few minutes ago that one of the problems with our human rights codes and the Charter of Rights is that they don't provide obligated organization the kind of detailed directions of what to do to become accessible. They provide they can't discriminate, they have a duty to accommodate, but they don't tell you how to fix your website or how wide to make the aisles in your store or how high to make the shelves so that they're accessible to people with disabilities. An accessibility standard can fill that in. And it can do it by setting out rules in a particular area of human endeavor of what needs to be done and when to become accessible. Now, an accessibility standard can either govern a sector of the economy or a pervasive area of human activity. Let me show you what I mean. The government decided early on, after this law was passed, to make initially 5 accessibility standards. One addressed an area, a particular sector of the economy, that's transportation. So the idea is that they can make a standard that will spell out rules of what's needed to ensure that transportation services are accessible to people with disabilities as passengers. But 4 of the other standards were meant to focus on areas of not one sector of the economy, but recurring activities in all sectors of the economy. One was customer service, one was employment, one was the built environment, and one was information and communications. So any organization may provide customer service. The customer service standard is to spell out what they need to do to provide accessible customer service. Any organization can have a built environment, an office or stores or whatever. They too, a built environment standard, if it was passed, would provide for ensuring that built environment is accessible. Every organization can have employees. An employment accessibility standard can spell out what an organization must do as an employer to ensure accessible employment for employees with disabilities, and so on. The design of the legislation contemplates that the minister responsible for it will decide what standards need to be made. And they can't just say, oh, I just want to make a couple, because under the Act, they're required to make all the accessibility standards necessary to achieve the purposes of the law. So what would an accessibility standard include? Well, what it can do is set specific rules of actions needed to be taken to address certain recurring kinds of barriers that the government has identified and wants to act on. And it can spell out what needs to be done, and it can also set timelines. It's expected to set timelines. This is what you got to do, and this is when you got to do it by. Now, these rules don't have to be one size fits all for all organizations. It is open to the government in designing an accessibility standard to have different rules or different timelines depending on the nature and size of organizations. So, for example, they might have different timelines or obligations for government as compared And the public sector is contrasted with the private sector, or big organizations is contrasted with smaller organizations. But all designed to still achieve that objective of making sure that that sector of the economy or that area of human endeavor, employment or the built environment, will become accessible to people with disabilities across the board by 2025. And these standards, so you might ask yourself, well, do these standards displace the Human Rights Code and the Charter of Rights? Well, we were worried to make sure that they can't ever take our rights away, that they can't make us any worse off as people with disabilities. And so we want a provision in the Aoda, a very important provision which requires that if there's two different laws on accessibility, the strongest one always prevails. So if an accessibility standard is passed that's weaker than my rights as a blind individual under the Human Rights Code, I can always go to the Human Rights Code, enforce it, and enjoy the stronger protections. If, on the other hand, an accessibility standard were enacted that gives me more than the Human Rights Code provides, or requires action sooner than the Human Rights Code, then those standards don't lose their force just because they demand more than the Human Rights Code. In fact, they will prevail. And if you think about this, the idea underlying these standards is that they will do two things. That were absolutely central to the campaign for this legislation. The first thing that they will do is that they will provide obligated organizations with clear directions on what they need to do. So if you run a business or a school board or a store or a college or a university or a hospital and you want to know what you need to do to become accessible, if these standards are designed properly, you'll be able to read them and they'll be essentially your free advice. They will also avoid the need for obligated organizations to each reinvent the same accessibility wheel, try to figure out what they need to do to become accessible. Obviously, they got to look at their particular circumstances, but a website's a website, and if there are problems with website accessibility, as they often are in ensuring that they're designed in a way that people with dyslexia, vision loss, or certain other disabilities can access them, then the same rules should apply across the board. And that's an advantage to everybody and a cost saver to business. And if we can save, and obligated organizations, if we can save the money, we get more action. The other thing that these standards are aiming to achieve is to the extent we can, alleviate from people with disabilities the burden to have to fight barriers one at a time. See, under the Human Rights Code, yes, all these organizations in the community have an obligation to obey the Human Rights Code, but it shifted the burden on people with disabilities if they face a barrier to go file a human rights complaint and try to get a tribunal ruling that, yes, the Human Rights Code does require you to do X. As an example, back in the mid-1990s, I, as a blind individual, was upset that the Toronto Transit Commission did not require its subway crews to announce subway stops over the PA so I could know where I was. So I had to file a human rights complaint, and it took years to litigate. I won. That's why you hear stop announcements. And similarly, I had to then sue them to force them to bring a human rights complaint to force them to announce all bus stops and streetcar stops. And then, even after I succeeded there, if other municipal transit authorities didn't do the same thing, there was a possibility that other people would have to bring the same complaints to fight the same barriers, one organization at a time. That's an absolutely brutal barrier, a burden to dump on people with disabilities. Believe me, I know, having brought these cases myself as the complainant. And the idea is, if we could get accessibility standards that spell these rules out, that would relieve that burden from us. For example, the Transportation Accessibility Standard that was passed in 2011 provides that all municipal transit authorities have to announce all bus and all route stops. So that's now spelled out there in very clear language. So those are all the advantages that accessibility standards can have and benefits. And the thing that's especially useful is that it's a nice balance between the needs of people with disabilities and the needs of obligated organizations, because the obligated organizations get the clarity of actions they need to do, but they don't get relieved of any of their obligations under the Human Rights Code, and people with disabilities don't risk losing anything through the enactment of accessibility regulations. They can only standards. They can only gain and benefit from their enactment. So, where do these come from? Where do they get accessibility standards from? Let me take a few minutes to describe the process for their creation, because it's all spelled out in the AODA in some detail. We negotiated extensively over this when this bill was before the legislature from 2004 to 2005. And it's different than the process for enacting regulations elsewhere in the government. Normally, if the government if they've got a power to make a regulation under some law, so the bureaucrats decide, do some policy work, and they come forward with a proposal, and it comes to cabinet, and cabinet can vote after they do some consulting, as much or as little they choose to do, and it's the law. And if they want to amend it, a new government or a new cabinet or that same cabinet can just simply amend it. And it's not done in public. It's done in cabinet meets in private. Well, the AODA spells out a mandatory, detailed regime or set of rules for how an accessibility standard must be made or amended. Let me describe it to you. The first step is that the minister assigned responsibility for the AODA, at this time is called the Minister of Accessibility. That minister has to decide, in consultation with their cabinet colleagues, that they want to make a standard, that they want to develop a standard in a particular area. So I mentioned back in 2005, 2006, when the AODA was just passed, they decided on a first set of 5 standards, the ones I mentioned. Well, later, we came along, my coalition, the successor to the ODA committee, the one I now chair, called the AODA Alliance, and we said, we want some additional standards made. The first 5 are important areas, but there are other areas we wanted. And I'm going to use an example of one to illustrate how they're made, because it's in the works right now, and I'm in the middle of that process as a participant. So one of the ones that we said to the government they need to develop is an accessibility standard in the area of education, both kindergarten to grade 12 education and post-secondary education. So the first thing we had to do is we had to go to the government and make the case. And we said, well, look at our schools. They're full of barriers. Students with disabilities face a lot of barriers. So do in the K-12 system and in the college and university system. And those barriers recur. They recur from school to school, from college to university. They're not all identical, but the problems recur, and there's a pressing need for there to be clear rules on what needs to be done to remove and prevent them, because an education system full of barriers hurts a lot of students with disabilities, impedes their access to an education, and that can impede their access to competitive employment in their adult years. And it's bad for individuals with disabilities, it's bad for their families, it's bad for the economy. Well, we brought that case forward starting in 2009, 2010, and it literally took us 6 years to convince the government, then under Premier Kathleen Wynne, in December of 2016. She finally agreed, yes, we will develop an education accessibility standard. Now, that was way too long and shouldn't have taken that long at all. If you want to see what that campaign required, you can go to our website. We have an education page, www.aodaalliance.org/accessibility, or pardon me, /education. www.aodaalliance.org/education, and there you will see this whole saga unfolding. Well, finally, the Premier said yes. We made the case, they agreed. She agreed. So what's the next step? Well, under the legislation, the next step is the government has to appoint an advisory committee to develop recommendations for the government on how that standard, or what that standard should include. This committee doesn't actually pass the standard. They don't enact it. They make recommendations which will be submitted to the government. That committee is called a Standards Development Committee, and it's created under the terms of the Aoda. So what the minister has to do is, if the minister decides that there's going to be an education standard developed, the minister has to appoint an Education Standards Development Committee. Now, in the case of the education portfolio, excuse me, the government back in 2016, 2017 thought this is such a huge topic that we really need to set up two standards development committees. One to deal with kindergarten to grade 12 or K-12 education, and another one to deal with post-secondary education. That made sense. And they had appointed those, so they went about appointing those two standards development committees. So who sits on these committees? Well, the government posts an invitation to apply, and people can apply. And the expectation and the requirement is there have to be representatives from the disability sector, the disability community, and there have to be representatives of from the sector of the economy that's going to be regulated. In this case, the education sector. So the government was to eventually appoint a K-12 Education Standards Development Committee. I sit on that committee as one of the representatives from the disability sector. There are representatives from different disability organizations. There's representatives from teachers' unions, school boards, and different professionals from and people working in the education sector. Similarly, there's a post-secondary education standards development committee with disability sector representatives and also representatives from colleges and universities in Ontario. Now, does the Aoda require some proportionality of each of these sectors? And the answer is no. And when the government initially was setting up standards development committees in 2006, they were lopsided, with the disability sector being a minority that was always being outvoted and outmaneuvered. So in the 2007 election, our coalition went to the party leaders and asked them to commit that if elected, they would ensure that at least one half of each standards development committee would be disability sector representatives. The Liberals won that election, made that commitment, and that's been the case ever since, for the past 13 years. Even with a change of government, that practice has remained. So, what? Now let me talk to you about how one of these committees works. To some extent, it's spelled out in the legislation. To some extent, it's not. Spelled out in the legislation is that the minister responsible can write a letter to the committee officially spelling out its mandate. They can designate what the topic is you're going to deal with and can set some guidelines over how you're going to deal with it, or can identify some areas that they think are important to deal with. And in our committee, they've done that, and with the others, and these are all posted online. That can be very helpful, but it can also be very constricting. The government, for reasons I think may have been well-intentioned but misguided, have provided that we must pass we can't pass a recommendation unless it's supported by 75% of the committee with half representation from the disability community. I think they're trying to ensure that the disability sector has an equal voice, but that actually, the way it's actually operationalized, could allow a minority of 26% of the committee, including nobody from the disability sector, can stymie and block a recommendation from going forward. Rather misguided, trying to get that changed, but that's not spelled out in the legislation. It's in the mandate letter. The minister could change it tomorrow by revising the mandate letter. Well, then the committee gets to work. The committee is appointed, it gets to work, and it can get input or support, staff support, from an office at the Ministry of Accessibility called the Accessibility Directorate. And the anticipated regime is that the members will get together and they will essentially do the following. They're going to first, they should to collectively learn what their job is, because some of this may be quite foreign to them. They may know education, but they may not know this legislation. Then they can collectively, through their knowledge or through their avenues of reaching out to the community, find out what are the barriers in your sector that need to be addressed. What are the barriers in the school system? And can try to put together a list or at least have a sense of what needs to get fixed. After that, they can collectively work to find out what solutions should be, to discuss what solutions should be legislated in the regulation. And these can go in varying degrees of specificity. They can be very specific, they can be more general. It really depends on the situation and their judgment of how they want to recommend that the government proceed. And the final thing they can do is spell out what the timeline should be that they recommend be included in the standard. And that can vary depending on the size of the organization. It doesn't have to be one size fits all. So the idea is that the Standards Development Committee can have a series of meetings where they put their heads together and try to undertake these activities. They're quite flexible in how they go about it. Ours divided ourselves into a series of subcommittees, divided the work up based on categories of barriers, tried to come up with ideas and share them, and work towards formulating views and learning as we go along. That's step collectively is step one. Put your heads together, try to come up with some an idea of what the recommendations are. And in doing that, they can reach out to the community to get input. They can bring in representatives from experts or representatives from the community to speak to the committee, and we've done that. They can, and I've gone to speak to other standards development committees to offer input. They can also turn to the government and ask the government to come and make presentations to the committee about some area to learn. Well, what is going on now? What's being tried now? So they can have a sense before they recommend reforms of what's the state of the art right now. And we've done that too. Now, this process up to now is meant to be one which the public can follow. And the AODA specifies that the committees are required to keep minutes and that they must be posted publicly. And also, it contemplates progress reports posted publicly. So this is not just to go behind closed doors and have secret discussions and that's it. If it's done appropriately, there should be an ongoing opportunity for the public to see what's being discussed and how it's being discussed, so they can have a sense of whether there's areas where they might want to add or make suggestions or forward those to the committee. Once the committee has, and by the way, it's varied from committee to committee how much they've actually shared with the public. I've seen minutes of some of these committees where you'd read them and you haven't the slightest idea what they've actually discussed. They're so high level that they tell you almost nothing. I've seen other minutes from other standards development committees that are more specific. Well, after they put together their ideas, what happens? Well, they develop a report with all of their recommendations, and it's a draft report. And under the AODA, the Standards Development Committee is then required to submit that to the government, and the government makes it public. And there's a period, I believe it's 45 days, it can be extended. We've asked, as a community organization, we've asked to have it extended in the past. There's a period during which the public can then provide input. The Act doesn't spell how that input should take place. In recent years, it's done simply by inviting people, to send in written submissions. But back in the earliest years of the AODA's implementation, they actually had a more open process where they held some community meetings where you could come and make presentations in person to give feedback. That feedback is then brought together and provided after that feedback period to the Standards Development Committee. It then gets back together and goes over its recommendations and the feedback on it and decides from the feedback, do we need to change anything we've recommended? Have we left anything out? And so on. And then the committee eventually formulates a final report to submit to government. I will tell you, I've been involved now in this in both capacities for most of the standards development committees that have been in progress. I and my coalition, we've written briefs and submitted them over when we see their draft recommendations and make suggestions on what we like, what we don't like, what we say is missing, what we say needs to be changed. And now that I'm on a standards development committee, I'm right in the middle of working on actually helping write or give input into recommendations. And at the time I'm recording this, we're just weeks away from finalizing our draft report and sending it out for public comment. Well, after the Standards Development Committee has drafted its draft recommendations, gotten public input, reviewed that input, and finalized its feedback, then under the Act, it's done. It submits its final report to the government, which the government is then required to again make public. It is only then that the government is entitled to enact an accessibility standard in that area. It must be preceded by these consultative steps. And at that point, the government can enact what the committee recommended, some of what the committee recommended, none of what the committee recommended. It can vary what the committee recommended. It's not constrained to simply approve or disapprove. It could write something different. And I will tell you that every accessibility standard that's been enacted to date has always been weaker than whatever the Standards Development Committee recommended, and sometimes substantially weaker. And the government at that point doesn't just enact it. The government decides what it wants to enact. It's then required to post a draft of its regulation that it's proposing to enact. And that has to again be available for public comment for a certain number of days. And after it gets that input, it can then make final changes if it wishes, and then the regulation can be passed. Once it's passed, it's the law. Now, at that point, is it done? And do we just get into enforcement? Well, actually, no. Because under the Aoda, there is a requirement that within 5 years, after it has been, an accessibility standard has been enacted, the government is required to appoint another standards development committee. It can be the same people, it can be different. It always has been different. Largely has been different. Absolutely everyone's been different. But in any event, another standards development committee to review the first one and to decide with the experience of up to 5 years, is this thing achieving the goal of full accessibility by 2025? Is there anything missing? Is there anything we need to change to make sure that the goal of the legislation is achieved? So if you can imagine, for example, in 2011, an information communication standard was passed that set requirements for web accessibility. Well, those requirements were helpful at that time, but we've had since then the arrival of mobile devices, mobile apps, and so on. They were not covered there because they didn't exist. And now that's an important area that needs to be regulated. A transportation standard was passed in 2011, as I mentioned before. It covered a little bit for taxis, nowhere near what we need. But it didn't say anything about ride-sharing programs like Uber, or services like Uber, because of course they didn't exist. Now that's an important area that needs to be addressed. So the idea of this 5-year review, and it doesn't have to wait 5 years, but the idea of a 5-year review is it's a chance to say, hey, is this working? If not, what more do we need to do to make sure we get to full accessibility? So far, there have been 5 accessibility standards passed. There have been reviews completed of 2 of them, and the government, one led to almost inconsequential changes, nowhere near what we needed for customer service. As for transportation, the review committee made recommendations that were extraordinarily weak, and the government in 2.5 years has done nothing that we've seen with them, not made any changes. And there are other reviews still going on. And this is supposed to carry on, review after review, through the mandate of the legislation to ensure that the purposes of the law are achieved. So that is a very involved consultative process that, if it works well, should be able to bring the voices of a lot of people together to come up with creative ideas. one of the major problems that I've seen with it over the years, and that we've gotten feedback, is that the Government of Ontario, the Accessibility Directorate, has been entangling itself too much in the work of these committees, not just supporting them, but in a lot of ways trying to steer where they're going. In the past few months, that has reduced significantly with our work, and we've been left more to just do our own work, and they just facilitate the meeting happening. And that has led to progress happening quicker, and I believe more effectively. Time doesn't permit me to go in detail to tell you about ways in which this needs to be improved, but there are a number of ways where I believe it could be substantially improved. So that's the whole mandate of the government for its first of its two responsibilities: coming up with these regulations and getting them passed so that people with disabilities have a clear clarity on what they can try to get under the AODA, and obligated organizations have a clear sense of what they need to do. It is important to understand that at no point can an organization just say, well, my website is AODA compliant, so that's all I got to do. If the website standard that is enacted is strong enough to fulfill the Human Rights Code obligations, then that's true. But in many cases, the accessibility standards enacted to date are helpful, but considerably weaker than the Human Rights Code. Sometimes just somewhat weaker, some substantially weaker. And to that extent, compliance with the AODA is not presumptive proof or conclusive proof of compliance with the Human Rights Code. What's the government's second obligation? Well, the government's second obligation under the AODA to fulfill its job of leading Ontario to become accessible by 2025 is to enforce the law. And this was, remember I said earlier on that there were two problems that we encountered with the Human Rights Code and the Charter of Rights. One is they didn't provide enough clarity to obligated organizations of what they need to do. Well, these accessibility standards, if they're done properly, would provide that clarity. And the second problem that we identified is that those laws required individuals with disabilities to become essentially accessibility cops, filing proceedings either under the Charter of Rights in court or under the Human Rights Code, using human rights commissions or tribunals, whatever is available, and then fighting barriers one at a time. To deal with that second problem, the idea in the AODA's design is to provide a regime of law enforcement, of public law enforcement, and one that doesn't require the individual to be the private accessibility cop. Well, what's that enforcement regime look like? It provides that the government, the Accessibility Directorate, and so on, can have a number of officials with appointed with enforcement mandates. They've got fancy names, directors or inspectors, and they can have power, in effect, to conduct inspections of obligated organizations, to go in and look at what they're doing, to see if they're in compliance. It can also provide power for public officials to issue, if they find an area where an organization is not in compliance, to issue an order called a compliance order, which essentially says, here's what you're not doing, here's what you got to do, and you got to do it by this date. And a failure to comply with that can trigger the next step, which are monetary penalties, which can be issued. Now, for due process purposes, if an obligated organization is the subject of a compliance order or a monetary penalty, and they object to it, they say, hey, I'm in compliance, I've done enough, or I shouldn't have that penalty, or it's too high. The Act provides for, the AODA provides for an appeal to a tribunal to contest that. So the other thing the AODA provides as an enforcement tool is it provides a mandate to require obligated organizations to file reports over a period of time with the government. They're essentially self-reports on whether they're in compliance. They don't, as designed right now, they're not, certainly not detailed. It's not like doing your tax returns, more where you've got to go into all the details of how much you've earned and how much you paid. It's more a matter of simply declaring, yes, I'm doing this, yes, I'm doing that, and so on. It's self-reporting. So those are the enforcement tools. The Act doesn't provide for a complaint mechanism for a person to file a complaint, but it doesn't require the Act to provide it. It is open to the government to have a place to call or report violations that inspectors or directors could look into if in their law enforcement discretion they consider it appropriate. So that's the enforcement regime that the Act contemplates. This doesn't displace any of the Human Rights Code enforcement or the Charter of Rights enforcement, the right to bring individual claims. It's a separate process completely. Now then, with those two major roles of the government, you're wondering, how's it working? Well, let me turn to one other major part of the legislation because it helps answer that question. When this was passed, those advocating for it and the government looking at developing it wanted to build in some checks and balances. One was to require the minister to make an annual statement on how things are going, but we didn't have a whole lot of confidence that that was going to do much because these ministers, when they make these statements, I don't care what government they're from, they will have their public officials write a lovely statement that talks about what a wonderful job they're doing and how deeply they're committed, and they're not likely to be self-critical because that's just the way government is. But there was another component built in that's absolutely essential. And this is the idea that every few years, on a schedule that the legislation mandates, the government is required to appoint an independent person to conduct an independent review. Think of it as taking our provincial temperature, give us a checkup, and to report publicly on how things are going, how we're progressing, and on make recommendations on anything that needs to be changed. The first independent review had to be appointed within 4 years of the law being passed. That was done in 2009. They appointed a former cabinet minister, Charles Beer, to do it. He had to report within a year, which he did, made public in May of 2010. The second independent review had to be appointed within 3 years of the Beer report being issued. The government violated that law by delaying weeks. We had to go public and campaign to get them to obey their own law. But that second independent review was appointed in the fall of 2013. It was conducted by former U of T law dean Mayo Moran. She reported by the latter part of 2014, and that was made public in February of 2015. The third independent review was appointed in the late winter, the winter of 2018. The person appointed to do that was former Ontario Lieutenant Governor David Onley, and he rendered his report on the 31st of January 2019. And those reports are all available on the Aoda Alliance website at www.aodaalliance.org, and our responses to them. In all cases, we largely, very substantially supported what they had to say. We also submitted very detailed briefs in hundreds of pages on what the problems were and what findings we urged them to make and what recommendations they needed to make. But each independent review is required under the Aoda to hold a public consultation, including, but not limited to, consulting people with disabilities before they render their report and make their recommendations. If I summarize their reports very briefly, and if you go to our website, you'll see a lot of detail, they all three, at different stages in the process, basically say the same thing. Yes, there was big celebration at the start, and yes, the government got started intending to do good things, and the business community and others are supportive of the mandate of the legislation and so on. But they found that throughout this entire period, successive governments have not shown the necessary and appropriate leadership. They've been moving far too slowly. The standards they've passed, while helpful, are too weak. They don't cover all the barriers or anywhere near all the barriers we need. They've left out major priorities. They are in some ways confusing and hard to implement or they're not user-friendly. They've repeatedly found that the government enforcement of this law has been extremely poor and weak, largely based on revelations that my coalition, the Aoda Alliance, made public. If you go to aodaalliance.org/enforcement, you'll see that the history of that, including fights under the Freedom of Information Act to just reveal the extent that the government has known of rampant non-compliance in the private sector, has had unused resources for enforcement, and has done an extremely paltry job of actually enforcing it over a period of 5 years. I think there were a total of 5 monetary penalties imposed, total. So the lax enforcement has been a serious problem. And this culminated perhaps in the most blunt statement in the report of the third independent review, that is by David Onley, where he described progress on accessibility in Ontario. Remember, this is 14 years into the 20-year event horizon for this law, as being at a glacial pace. He described Ontario being a province full of, his words, soul-crushing barriers facing people with disabilities, and the goal of full accessibility by 2025 nowhere in sight. Sadly, as with the two previous governments, the governments in receiving the two previous reports, there's been no comprehensive plan announced to implement his recommendations, and we've been campaigning for that kind of action. We've been doing this over the years in response to each of these reports. There was recently an op-ed, a guest column in the Toronto Star published, co-authored by the 3 authors of these 3 independent reviews, uniting to say that most of their recommendations have not gone implemented and that this is a disservice to people with disabilities, which was an extraordinary unified statement for them to make. Accurate, but extraordinary. So let me conclude with just a couple of thoughts for AODA 101. First is, this is the Ontario story. What about the rest of Canada? Well, 2 other provinces have passed accessibility laws after the AODA was passed. Manitoba in 2013, Nova Scotia in 2017. Other provinces, particularly British Columbia, have committed to passing it. Others are looking at it. And in 2019, the federal government passed the Accessible Canada Act. This is all traces itself to the beginnings of the movement in Ontario. What do we need a federal law for? Well, because under our Constitution, most of the barriers that people with disabilities face are in the provincial sphere, the sphere that the province can regulate. But there are a number that only the federal government can regulate. Banking, telecommunications, radio and television, postal services, federal services, just some of the examples that require federal regulations. And when the Accessible Canada Act was being debated, you can read that history at aodaalliance.org/Canada. We were very much involved in that campaign, but we tried to encourage the federal government to learn some lessons from Ontario. In some cases, the federal act is better. In some cases, it's weaker. One lesson that we said that was important for the federal government to learn, that we've learned in Ontario, is we said that both the process of developing accessibility standards and of enforcing the law should not, as it is in Ontario, be governed by a government ministry. It should be removed from the government of the day, because the government of the day is in a conflict. It's not only if it's the regulator, it's also the biggest organization that's got to obey these laws. That's a conflict. And so it's better to take the enforcement of the law and the development of recommendations for the law out of the government and place them with more independent organizations. Now, the good news is the federal government listened to a degree. Instead of having individual standards development committees, they created a national organization called the Canadian Accessibility Standards Development Organization. That's a mouthful. Within a year, it renamed itself Accessibility Standards Canada. It can decide which standards to develop. It's not up to a minister to decide. And it can develop recommendations as it wishes and then submits them to the government. And that's supposed to be more arm's length. It remains to be seen if it's going to be more effective. And second, enforcement was taken out of the government. Unfortunately, that was good, and given with the aim of making it independent. The problem is they didn't give it to one federal agency, they gave it to three. Part is enforced by the Canadian Human Rights Commission, part by the Canada Transportation Agency, and part by the Canadian Radio, Television, and Telecommunications Commission. And if you want to try to figure out who does what, I got to tell you, you better have a big bottle of Tylenol in hand, because it is one confusing headache. We had urged one-stop shopping with one agency to do all the enforcing, but the federal government didn't listen. So this message has carried forth beyond. In terms of if you want to learn more about this, let me just offer some quick resources. I've mentioned before our website. Go to www.aodaalliance.org. If you want to receive regular updates of what's going on and what are the cutting edge issues, you can go to that webpage and there's a sign up link to sign up to get our updates. So go to aodaalliance.org, go to the sign up link, plug in your email address. We're happy to send you our updates. We regularly tweet what's going on not only here but elsewhere around the world on the accessibility topic on Twitter. Go to @AODA And finally, we have a Facebook page, Accessibility for Ontarians with Disabilities Act. I mentioned before, we've got a whole bunch of videos online talking about all sorts of aspects of this story. This lecture is just going to be the latest edition of that. And I encourage you to take a look at those videos. I talked before about, in conclusion, I talked before about the need to tackle the barriers facing students with disabilities in our school. If we leave students without an effective education accessibility standard, they're left to have to campaign one family at a time, one barrier at a time, one school at a time to face these battles. Accompanying this video is going to be a shorter video that in which you'll see the kind of strategies a parent would have to use to undertake that kind of advocacy. It's quite a burden, and we're hoping that an effective K-12 education accessibility standard would make the kinds of efforts that I describe in that video easier to undertake and less necessary. Thanks very much.